Good evening, everyone. We're here less so keynote speakers. We're here to welcome you at McDermott, Will & Emery, this national global law firm. Our London headquarters here on the 46th floor. So congratulations on launching the association, and a warm welcome to all of you. We're here to talk, both Andy and I are compliance lawyers. Andy's white-collar crime lawyer, and I'm trade and sanctions compliance lawyer as well. We're here to talk a little bit about compliance risks for MSBs and sort of give you the global context on the problems and issues that we operate for our clients, as well as the regulatory frameworks. We'll take it really high level because for some of you, less things might be relevant than for others. So we'll just take you through some legislation, and we're open for questions if you'd like to ask anything. So here's me, and here's Andrew Butel, my colleague here on the left. I counsel clients on the EU and the UK sanctions regimes. As I have mentioned, I do act as a regulatory counsel for numerous trade associations. So it is not unusual for me to be in the setting where a trade association is being launched. And Andrew helps clients to navigate complex international and governmental investigations. So we're in different departments, but are doing very much similar things in terms of trying to avoid risks for companies, including the MSB sector. So we just put a few bullets together for you, which is very well known in terms of what compliance there are for MSBs, from navigating new regulatory risks and obligations. So from corporate criminal liability, licensing, AML, counter-terrorist financing and fraud, to, of course, addressing geopolitical uncertainty and what's happening in the world. Therefore, sanctions and export controls come in, as well as what your association has already spoken to, is adapting to new technologies, obviously processing crypto, engaging AI, and as well as thinking about cybersecurity issues. I will, from there on, take it to Andy, who will speak a little bit about his area and how he assists his clients in the sector, as well as how what he does might be relevant for a MSB sector.
Thank you. So I guess I'm going to talk very quickly about a new piece of UK law, which is something my clients are grappling with quite a lot at the moment. My clients are typically major corporates, PLCs, large private companies, who are exposed to this new legislation called the UK Economic Crime and Corporate Transparency Act. That has two major effects, which really broaden the ways in which companies can be liable for the acts of their directors, managers, agents, consultants, and a wide range of third parties who act on their behalf. I'm not going to go into a lecture on UK law history here, but traditionally in the UK, it was very hard for companies to be found criminally liable for the acts of individuals. Typically, the wrongdoing had to be perpetrated by a board member, effectively. In practice, in very large organizations, that was quite difficult to establish in practice, because often the paper trail ends at a certain level. The senior management were often insulated from responsibility for wrongdoing. After a lot of lobbying of the government by law enforcement agencies like HMRC and the SFO, this new legislation was introduced, and it's had two seismic changes to the way in which companies are found criminally liable for the acts of individuals. The first one we call the senior manager regime. That's already in force, and I'll touch on that in a minute. And the next one is a new offence of failing to prevent fraud. That comes into effect on the 1st of September. At the moment, the UK Serious Fraud Office and other prosecutors in the UK are really, really excited to use these new powers. They're making announcements all the time about how they're super keen to go after companies. This new law comes into effect. I think, as we'll see, you guys might be protected from one of them unless you meet certain size thresholds in your business. So one of them at least might be a kind of a forward-looking compliance obligation rather than something right for now. So this is the first reform I was talking about. This one's pretty simple in practice. In effect, now, rather than the prosecutor having to prove that someone at board level was involved in criminal conduct, companies can be liable for quite a wide range of economic crime offences, which you see there, so long as they're committed by someone who is defined as a senior manager of the company. The range of offences there are, I guess, quite obvious, or the serious financial crime offences you can think of. So the next question would be, well, who is a senior manager of a company? What's the legal test? Okay, I'm not going to read this out, but it's a very broad definition. Effectively, anyone who plays a significant role in organizing or managing the whole of a business or the part of a business is defined as a senior manager. There's been government guidance issued on this, which confirms that it doesn't just include people at kind of senior executive level. It can include people in compliance functions, HR, internal audit, anywhere in the business, so long as they meet this quite broad test. So all of a sudden, major companies now, there's a huge range of individuals who previously could commit wrongdoing, but now that wrongdoing can be attributed to the company, and the company itself can be prosecuted. The reason why law enforcement is excited about this, companies have deeper pockets than individuals, so it's much more attractive often for the government to go after a company, thinking they may be able to extract a large settlement from them rather than trying to prosecute an individual. This is quite detailed, so I won't go through it. We've discussed the wide definition of senior managers. The law is also quite broad in jurisdiction. As you might be aware, the UK bribery offences, sanctions offences, terrorist financing offences have extraterritorial effect. So that in effect is now rolled up into the new regime. There are things companies can do to help them. Maybe avoid liability for the acts of their senior managers. The first thing they can do is to try and prevent senior managers engaging in misconduct in the first place. So we're advising companies to identify their senior managers, train them on the whole host of compliance obligations they have, and making sure suitable policies and procedures are in place. I was thinking about how this might apply to your businesses and the sector. I'm probably right in thinking companies are maybe a little bit smaller, so many of you already are perhaps senior managers of your companies according to the definition. So even if you're not at board level or director level, your actions now might expose your company to direct criminal liability. So it's yet another reason to double down on compliance and all of the associated procedures. The next offence, this one might not apply to many organizations in the room yet. It applies to something called large organizations, and the thresholds are quite high. So a company, to be a large organization, has to have over 250 employees, 18 million in total assets, and or 36 million in turnover. Hands up if anyone's business meets that threshold yet. Okay, you're on the hook then. And then what this offence then does is all companies who meet that test of being a large organisation, not only can senior managers expose the company to liability, but the net is even wider in respect of specified fraud offences. As you can see down the bottom, the definition there is associate. So any employee of a large organisation or its agents or subsidiaries, consultants, intermediaries, basically anyone who performs services for that large organisation, if they commit a fraud offence subject to certain tests, the company can be liable. So it's this theme of, in effect, new laws widening the scope of individuals that can make a company liable. This is very detailed. I won't go into it, but the key takeaway is fraud is quite widely defined in UK law. There's a whole host of different statutory offences and conduct in quite a wide range of ways can ultimately fall under the definition of fraud. Again, this new legislation can apply to conduct that takes place out of the UK. The saving grace, though, here is that there is a defence. You might be familiar with the concept of adequate procedures under the UK Bribery Act. Well, this law introduces the concept of adequate procedures to prevent fraud. It's a similar concept, and the themes are familiar in terms of due diligence on third parties, policies and procedures, training, risk assessment, etc. Finally, there's a slide here on AML and CTF in relation to MSBs. Now, I'm hoping that you all know these things more than me because I'm not an expert in MSB compliance, but I was looking at this the other day, and it seems like the obligations are very, very onerous that you all face. Filtering down from the money laundering regulations, the failure to comply with those can obviously be very severe individually and for your organizations. I was, I suppose, glad to see that HMRC in its wisdom published this 100 pages of guidance on how you might comply with the MLRs. The themes are quite familiar, but the detailed implementation of those is obviously the challenge in practice. There's also, and again, as I'm sure you're aware, government guidance on red flags in your sector. Again, quite user-friendly. If you're not familiar with it, then there's a link on the slide. And I'll probably hand over to Raminta now, unless anyone has any questions on this stuff I've just run through very quickly.
Thank you very much, Andy. So I'll stand up. I think this works a lot better. If I know that's okay, I can change the slides. So if you haven't read any relevant legislation with regard to sanctions, I've heard it over the news over the last 2 years, particularly since 2022, you would have heard a lot of new sanctions have been introduced in relation to making money available, trading, or making goods available to Russia and Russian counterparties. That applies accepting cash from Russian nationals, depending on the legislation. The European Union and the UK and the US are applying increasingly more financial sanctions, which will be relevant for your sector, as well as a lot of other financial services sector, including banks. The difficulty is that in addition to what Andy was saying, in ACTA coming into force, AML, KYC will be instigated and accelerated by the ample of other legislation that's coming in. And whilst we might think that for small companies or perhaps facilitators of transactions, particularly monetary transactions, liability or responsibility might not lie with a person or a small business, that is unfortunately not the case when it comes down to sanctions regime. No doubt you will all be aware there are certain geographical locations like Iran, Iraq, North Korea that have been or have had historically complete trade embargo. So no matter where you traded from or no matter where you were based, certain territories were just a no-go for actually facilitating financial transactions with. Governments have gotten smarter. Imposing complete embargoes in relation to certain regimes is not necessarily the most effective way, and or might restrict certain huge jurisdictions such as Russia to, a lot of exposure where the business has been done historically, and the UK and the US as well. So now EU, UK, US, and other jurisdictions are applying, so to speak, targeted sanctions, which means that specific sectors will be targeted or specific transactions will be targeted, and you might get caught within it. And the reason why we brought in sanctions here for you, it's kind of a doom and gloom for Andy and me at the launch of an association to talk about ACTA and sanctions compliance. But the reality is that particularly for your sector, these are very difficult laws to comply with. And typically, the view is that the smaller you are, it's not my responsibility, somebody else's. I can't control who is actually accepting money in Afghanistan. I can't control who is giving me money in the UK on the high street. And unfortunately, it doesn't matter. And the regulator will come and get you, no matter if you're just are actually, with regard to sanctions, a large company. Importance of regulatory due diligence cannot be understated anymore. As I said, sanctions compliance is no longer a nice to have and the US thing. Or if I don't trade US dollars, if I don't have Americans involved, there's no risk and harm in me facilitating certain transactions. So EU and the UK have comprehensive sanctions regimes, and there's a significant increase in enforcement and investigations. There are huge financial risks associated with it, as well as criminal liability where the breaches of sanctions have occurred. Of course, there are reputational risks, and I will give you a few examples. Some of the industry participants, MSBs, that you might be aware of, where rather than getting a penalty, actually the companies have been listed and remain listed by the Office of Financial Sanctions Implementations as the companies that have breached sanctions regimes. It is an extremely complex area of law. I won't bore you with it, but it is really, particularly with Russia and other regimes, where increasingly it is being used as a tool to change certain political regimes. It is very difficult to follow. So a good example as well is lifting you might have heard, you might have seen on the news, sanctions are being lifted with regard to Syria. Can we do business now? Can we start sending them money? Are AML requirements smaller than they used to be? And the reality is, a lot of banks, particularly involved, will say, it's all very well, the sanctions have been lifted. We're not going to facilitate transactions for a lot of other risks. So it is hard to follow. And I think for smaller companies, it is extremely hard to follow for a reason, because if there is a compliance person within the company itself, then that compliance person is dealing with everything. That compliance person is dealing with AML, with KYC, with sanctions compliance, and a lot of other things that might be relevant to get the business running. So a little bit what actually is prohibited with regard to particularly for MSB business that might be relevant. There are asset freeze restrictions that the US, the UK apply. So all funds and economic resources directly and indirectly belonging to, held or controlled by a designated person must be frozen. You'd ask, who are the designated people? Some of you might be very well aware that there are huge lists with regard to certain jurisdictions of individuals or companies that will be blacklisted to actually receive funds or economic resources from individuals or companies that have affiliation with the US, EU, or the UK. So there are also prohibitions on making funds or economic resources available directly or indirectly to or for the benefit of a designated person. So you might say, well, it wasn't me that made money available to the general of an army of a specific regime because we've only sent it to Dubai, and then in Dubai someone went and picked it up. The reality is that everybody involved in a supply chain to facilitate making funds available to eventually blacklisted or sanctioned individual or company will be implicated for purposes of sanctions compliance. So sanctions in the crypto sector, we did one slide. It's not unique to crypto sector. It could have said MSB sector, financial sector, I think would have been the best way to put it for purposes of our conversation. So there is an obligation to freeze financial assets owned by sanctioned person or entities. So if you become aware that in the process of your AML or KYC, if you did run the sanctions checks, that you are in a possession of certain funds or economic resources, funds, money, cash, you name it, held by sanctioned individuals, there is a duty to disclose. There's a prohibition on providing crypto services to sanctioned persons or entities specifically, and that really involves crypto services, and specifically with regard to Russia, there are exclusive restrictions for this service. And particularly when it comes to crypto wallet accounts and so on. With regard to Russia, a lot of breaches have been detected, and the biggest risk is making services available to parties located in Russia or, for purposes of the UK law, Russian nationals, as well as under over 100,000 euros cash from Russian nationals as well. So these are the risks. And we have listed here a few interesting enforcement actions in that regard. So perhaps Wise Payments Limited is a good one, where there was a transaction of 150 pounds, whereby the money ended up in the pocket of a person that was sanctioned under the Russia sanctions regime. Wise Payments disclosed it, and the regulator took a decision that they will not penalize in monetary value Wise Payments Limited. However, their name is all Office of Financial Sanctions Implementation's website, so it's a reputational risk. But here we've listed a few examples of where you can see that not performing your checks on whether there are sanctioned persons involved or inadvertently making funds available to restricted parties or restricted jurisdictions in certain instances might lead to significant financial penalties, but more importantly, pursuant to UK legislation, also potentially to criminal liability. So to the extent you can protect yourselves, try your best. There is a lot of guidance, particularly for UK market participants, for smaller companies, which is very, very unusual. It's only recently that both Office of Financial Sanctions Implementations as well as other regulators have even done little videos on how can small market participants protect themselves and what is the absolute minimum you need to do in terms of KYC or educating yourselves about sanctions regimes and applicability of sanctions for businesses, particularly where you handle cash, where that cash is being then sent over by certain software and ends up in jurisdictions of concern. And these jurisdictions, a lot of flags that we had listed where MSB Association had, nice, are jurisdictions of high concern in terms of fraud, in terms of how many individuals are listed. So we highly advise as much as you can. There are a lot of tools you can get your hands on, which weren't available even 6 months ago. And I think, this whole doom and gloom, but the reality is it's good. When you know the risk, you can control your risk and actually protect yourselves, protect your employees, and also contractually protect yourselves within the supply chain, whereby someone might have committed a crime, but you weren't part of it. So with that, I think on this positive note, we're open for questions, of course. So feel free if you'd like to know anything more in detail. Andy and I are happy to answer. Please go ahead.
One thing, I suppose that really important areas, so the individuals that can now be prosecuted.
Yes.
We have consultants or we have people in our businesses that might give us advice on an ad hoc basis. How does that work in relation to keeping things in check in terms of your system management? How do you keep that in effect, keep yourself out of trouble when you have so many moving parts in your business?
I guess a few thoughts on that. Due diligence, as always, the starting point. What are that person's bona fides? What are they doing? Where are they doing it? What controls do they have in place at their end? Can you verify their controls? What risk protections can you put in place, either in the contract? Things like audit rights, if it's very high risk, so you can insert it right in the contract. Look at their books and records in relation to the services they're performing for you. Can try and train them, send them your code of conduct.
So it's in relation to, for example, AI coming in. What I'm really, where they end up using things like AI and trying to get things across the line quickly because of deadlines, whatever else it may be. That process, how do we keep those balances in place to putting and implementing those new technologies and keeping not necessarily your ultimate team in place, but basically a team that can potentially change over time? Because a lot of these businesses don't have the same person working all the time.
Let me take this. So particularly if you will employ, and I think we've had with some of you this conversation before, we've opened the floor for speakers, but particularly where AI is employed and technology, software and technology is employed, to make sure that that software and technology is enabled to perform AML and KYC checks for starters, then the level of your KYC and AML checks might be adapted and tailored to encompass screening through certain sanctions checks, depending on where you operate. So the nexus will be what we like to call a nexus, is when do the laws apply and which laws apply will depend on within your companies, yourselves. Are you operating out of the UK? Are you sending US dollars? Are you, do you have an agent in between that is based in another jurisdiction that has different, perhaps AML, KYC, or requirements? And so that number one, these are the checks and also what your software and technology enables. Number two, if that software and technology enables you to geo-block, very frequently with regard to Russia, I have advised many times is, certain individuals from certain jurisdictions being able to access your software and technology, which enables you to transfer the money, might be of a huge problem, but AI and software and technology can actually allow you to geo-block. And then the question is, it's what Andy alluded to, is contractually to make sure that you're not implicated where there are numerous of parties involved in facilitating your business. So you need to make sure that everybody within your supply chain is aware of the obligations and that you have explained these obligations clearly and you set the boundaries as obligation finish. Now, it might not be so easy with what Andy's dealing with in terms of where your obligations finish, but for sanctions, there are some limits and certain protections that you can put in place.
It's also the question of controls. The further down the chain you get, the less reasonable it is to have procedures in place for 2, 3, 4 individuals or companies down the line, but it's about what's being reasonable in the circumstances.
And also that there are many means, even as if you're just running a company by yourself or facilitating certain transactions where sanctions lists, for example, are available online. You can literally manually, for bigger jobs, for bigger business-to-business transactions, look up what these companies are, and also there are helplines. Now, it's not so easy for physical individuals, but of course, for physical individuals, the risks are smaller if you have a person coming in, with £100 as opposed to £1 million asking you to transfer it somewhere. Well, thank you very much. Enjoy the view. Enjoy the weather once you're out of here. Enjoy the drinks. We have a few more speakers to go, I believe. And thank you very much for having us.